Classified Crime is on the case of Sarah Boone, and today we are going to do a recap of her family court case, starting with the initial filings in 2017 and 2018. Now, if you didn't see my post, check that out because I made a complete timeline of all the documents from 2017 all the way up to 2025, both past and futuristically, and a brief description of what they are. So keep that handy when watching this family court series. I just got access to the documents in the past couple of days, and the first detail I would like to point out is this financial section of the docket. It has an outstanding balance due of $295. Now, if you notice, there are other paid transactions on here, and all were paid by Brian's attorneys. So I wondered why this balance has been there since December 15th, 2017. Initial filing date was November 30th. They had a transaction assessment of $408. Nancy Weber, who was Brian's initial family court attorney, was marked as paying that. And then 12/15, we have this $295 assessment. June 19th, $6, and that was also paid by Nancy Weber on the 19th. Down to 2022, there was a $60 fee paid by Joshua Marital, who is Brian's current family law attorney. And then back to 16/2023, there was a $10 fee, and that was also paid by Joshua Marital. So I was wondering why this balance was there, what it was from. Well, we need look no further than this document dated December 18th, 2017 to see that it was sent to Sarah's attorney requesting the fee be paid for filing her counter petition. And that is still outstanding to this date, but none of us are surprised by this. All of Brian's assessed fees were paid, but Sarah just ignored hers completely even before she was ever incarcerated. Now, you might be wondering, Sarah had an attorney? Well, yes. As we can see here, the notice of appearance of Sarah's attorney, the Marks Law Firm, counsel name of Arthur Grossman III, was entered on December 1st. So Brian filed the initial divorce case on November 30th. The very next day, Sarah had her attorney file this notice of appearance. First day of December, just letting them know they are representing Sarah K. Boone. And how long did this attorney-client relationship last, might you ask? Well, it didn't take long, because a few documents later, I have this motion to withdraw as counsel of record from Arthur J. Grossman III and the Marks Law Firm. They filed their motion to withdraw as counsel of record on January the 10th, 2018. So 41 days after she retained this attorney, he files a motion to withdraw. And here are the reasons. 1, Sarah K. Boone is the respondent wife in the above referenced action. 2, the undersigned attorney has provided notice of intention to withdraw to respondent/wife in the above referenced case. 3, respondent/wife and the undersigned attorney have reached, shocking turn of events, irreconcilable differences. Now, where have we heard that before? See, this goes all the way back to 2017. They barely made it over a month before they had reached irreconcilable differences. But none of it is her fault, remember? None of it. 4, respondent/wife can receive all future pleadings and correspondence at the following address. And that explains why that $295 fee did not get paid, because Mr. Arthur Grossman probably did not get paid as well. So if Sarah is not paying her attorney, not just the retainer, but statements that they send out, they're going to withdraw as counsel, and they're not going to pay outstanding fees for her on her behalf. Okay, this is actually the first document filed in the Boone versus Boone family court case back in 2017, November 30th, 2017. Brian was the petitioner because he filed for dissolution of marriage. So it's pretty standard. Sarah is the respondent, and that is going to remain the case throughout the entire case. Brian will always be petitioner. Sarah will always be respondent because he initially filed and she had to respond to the initial filing. So this is pretty standard. It just says that action for dissolution of the bonds of marriage. The husband has been a resident of Florida for more than 6 months before filing. It tells the date that they were married and separated. The marriage between the parties is irretrievably broken. They have one child born in 2010. And it says the husband anticipates that the parties can agree upon and execute a parenting plan which is in the minor child's best interest. That is extremely optimistic on his part. Then we have equitable distribution. The parties have acquired assets and incurred liabilities, which require equitable distribution. And that's pretty standard too. Child support. This was interesting to me. Both parties have the financial ability to contribute towards the support of the minor child. Now, in family court, even if a parent is not employed, when the marriage ends, the unemployed parent is considered able to at least earn a minimum wage salary. So family court can calculate, even if you're unemployed, child support based on a 40-hour minimum wage work week. So that's what they would put into. There's a calculator they put both parent incomes into. And if one parent is unemployed, they use whatever the state minimum wage is at a 40-hour work week and estimate that that is the minimum they should be able to earn. And they base their child support off of that typically. I am not a lawyer. I am not a professional. This is just my personal experience. So that is something that courts do, whether you were working or not. The husband anticipates that the parties will enter into a marital settlement agreement, either with the assistance of their attorneys or through mediation. In the event that they are unable to do so, the husband reserves the right to amend the petition. They are both over 18 and were not in the military 30 days prior to the date of the filing. And I highlighted, furthermore, respondent is not mentally incompetent. Are we sure about that? Because she ended up having the evaluations. She's fit to stand trial in her criminal case, but is she mentally competent? I don't know. All right, attorney's fees. This was interesting too. The husband has retained the undersigned attorney to represent him. Should the wife engage in unnecessary or vexatious litigation, then the husband requests that this court order the wife to pay the husband's fees incurred as a result of the unnecessary or vexatious litigation. That was strategically placed in there, I believe, because he had to have known. He had to already, obviously being married to her as long as he was, he knew how she was going to react. So he requests that the court enter a final judgment of dissolution of marriage, that they equitably divide the assets and liabilities, that the court order an appropriate amount of child support and any other relief as deems necessary and proper, just and proper. And they're saying that they want to split the home. So this is an action for partition. So Brian, who was not currently living at the home, and Sarah, who was living at the marital home, both own the property. There's an unpaid mortgage balance listed at the date of that complaint and no other lien holders. And it says it's a single family residential dwelling. So the husband requests that they enter a judgment of partition, appoint a special master or clerk of court to make a sale of the property, either by private sale or at public auction to the highest bidder, and that each party's respective share of the cost of the action, including attorney's fees, be paid out of the proceeds of the sale, with the remaining monies divided among the parties in proportion to their interest. And then it's notarized, and his attorney, Nancy Weber, has signed and given a certificate of service that they sent a copy to Sarah's attorney that she filed on December 1st. So apparently she'd already retained him when they filed this. And then the same day, Brian filed his financial affidavit, which both parties are required to file. He basically put that he is an application developer, so he works in computer programming in Florida. He can make about $2,000 every other week. So he has his last gross income here at $45K, monthly gross at about $4,000. He lists all his expenses out, deduction, so that would be his net income per month. And then he lists their monthly expenses out, leaving him with a deficit at the end. So it ends up, instead of being a surplus, about a $500 deficit once you add up all the expenses. Of course, Sarah is theoretically contributing to the household as well. Watching a child is a huge contribution if you are a stay-at-home mom. I'm not insinuating that that's not a contribution. It is. But in Sarah's case, we can only speculate on what she was contributing is what I mean by that. All right. And then these are their assets. They listed the cash, the home, their automobiles. So this is probably where she got the $8,000 when she files later on. When we get to the current paperwork where she files her car, her 2011 Kia Sorento, estimating it at $8,000, I think she's getting it from these 2017 court dates. Documents, that were filed. So she's basing it off of this court paperwork that the Blue Book value in 2017 for a 6-year-old car was $8,000. But in 2025, it's not still a value of $8,000. We all know cars depreciate in value every year. And then the other assets they list, liabilities, showing a total net worth of about $87,000. Here on the left, we have the partition section of Brian's original petition filed on 11/30/2017, which I've already read. And then on the right, we have Sarah's counter petition filed on 12/15/17. But I wanted them side by side so you can see here in the red box are Sarah's responses to Brian's statements and claims. So I put them side by side. We can kind of see what she's either admitting/denying. So she admits, 1, that this is a petition for divorce, and admits 2, that they live at the listed addresses he provided. But she denies 3, I think, about the mortgage amount. We'll look at that a little bit later on. And then 4, she denies the partition claim and awarding attorney's fees out of the sale of the home. So she does not agree with anything he put really in 4. Okay, now for her counter petition part, she says the same thing, that this is an action for dissolution of the marriage. They have both been a resident of Florida for at least 6 months. She agrees on the date they were married, but thinks that their separation was on or about March 2017, and Brian says September. She does agree the marriage is irretrievably broken, that they were not in military service, that they do have 1 child. They did a uniform child custody agreement affidavit. But the mother is requesting that the parties be granted shared parental responsibility to make all major decisions affecting the welfare of the child, which include but are not limited to decisions regarding the child's education, healthcare, and other responsibilities unique to this family. The mother is requesting a time-sharing agreement in which the parties share equal time with the minor child. It is in the best interest of the minor child for the parties to have shared parental responsibility and equal time sharing with the minor child. So obviously this has to be amended because they cannot spend equal time with the child anymore. Support for the child should be established in accordance with Florida guidelines. Sarah wants the husband to maintain health insurance for the child, and that they should each be responsible for and pay a share of any uncovered medical expenses. That's very reasonable. Let's see. And she is requesting that the husband provide her up to 36 months of health insurance through Cobra. Now, if you've ever left a job or changed jobs, Cobra will mail you out a continuation of health insurance for a period of time while you're in between transitioning from one situation to another, and sometimes benefits don't start it right away. It is significantly more expensive than just continuing to pay the health insurance premiums through your job, because now your job is not paying a portion of those premiums. So if you do elect to continue the health coverage through Cobra, it's usually significantly more expensive to do so. So if they're divorced and she's no longer considered a qualifying dependent, he could file for the Cobra insurance, but it would cost him significantly more out of his check to cover her for 3 years, up to 3 years, than it would if you just add a qualifying dependent. It usually doesn't increase your premium that much, but if they're not a qualifying dependent and you're paying for that extended coverage, the employer is not paying any part of it. So that to me is not reasonable because of how much it would cost. It's usually just a ridiculous amount. All right, spousal support. The wife has a need and husband has the ability to provide temporary, bridge the gap, durational, rehabilitative, lump sum, permanent, or a combination of those forms of alimony to assist the wife pursuant to Florida rules and statutes. Through the course of the parties' marriage, the husband has been and still is the breadwinner of the family. This is a moderate term marriage of 13 years. So she's requesting spousal support, alimony, and we already knew that. Equitable distribution. During the marriage, the parties acquire various items of personal property. The wife seeks an equal distribution of all marital assets, including both tangible and intangible properties, including but not limited to any retirement accounts, pensions, and profit-sharing accounts, and requests the court to determine which of the parties' assets are marital and which are non-marital. The court should divide these assets between the parties pursuant to Florida statute. Further, the parties have incurred certain marital debts and liabilities. The marital debts and liabilities should be equitably distributed between the parties pursuant to Florida statute. Additionally, the wife would request that the court restrain the husband from incurring any further debt for which the wife may be deemed liable during the pendency of this matter. Real property. The parties jointly own as a marital asset the real property located in Winter Park, Orange County, Florida. This property is subject to equitable distribution and ownership, and equity should be determined and distributed by the court. Husband has vacated the home, and wife should be awarded exclusive use and possession of the home during the pendency of this action. So she says since he moved out, she should just get to exclusively use it, but she still wants him to continue to pay the mortgage while he is not living in it, I'm sure. Attorney's fees and costs. So let's see how she feels about that. The wife has retained the Marks Law Firm, PA, to represent wife in this action and has agreed to pay a reasonable attorney's fee, costs, and suit monies for this representation. The husband should be required to contribute to the cost of this representation pursuant to Florida statutes. Further, to the extent that the husband is unreasonable, engages in vexatious litigation, or refuses reasonable offers of settlement, then the husband should be required to pay for or contribute to the wife's attorney's fees, all 41 days of them, both temporary and on a final basis, together with suit money, including attorney's fees, pendant life, and the cost and expenses of this action. So she feels if he is unreasonable, then he should have to pay the extra attorney's fees. But she did not agree with that in his petition. Name change. She wishes to change her name from Sarah Catherine Boone, to her former name, Sarah Catherine Paulson. She says she's never pled guilty or nolo contendere to or have been found to have committed a criminal offense. This didn't age well. Now you have, regardless of adjudication. Wife has never been adjudicated bankrupt. Wife has no ulterior or illegal purpose for filing this name change request, and granting it will not in any manner invade the property rights of other blah, blah, blah. So I don't know what happened there. She did not change her name, but she did request it. Wherefore, the wife respectfully requests that this honorable court, A, award the wife the relief sought herein and dissolve the marriage of the parties, B, enter a parenting plan providing for shared parental responsibility and award equal time sharing for the minor child of the parties, C, determine the amount of child support to be paid for the benefit of the party's minor child and order support pursuant to the applicable Florida statutes, D, order that the parties should each be responsible for and pay 1/2 of any uncovered medical expenses for the minor child, including but not limited to co-payments, prescriptions, dental, orthodontic, optical, psychiatrist, psychologist, and orthopedic expenses of the children. So do you think that Sarah wants to be held responsible for this now? Because I'm sure Brian is incurring all kinds of medical expenses that she is not paying half of. She is not paying 1/2, and that is their current parenting plan. Just pointing that out. E, adjudicate the rights of the parties in regard to their jointly owned real and personal property and debts, including such marital and non-marital rights and obligations as may exist. F, grant an equitable distribution of the assets and liabilities that each of the parties has acquired during or as a result of this marriage, making use of all appropriate remedies, including but not limited to unequal distribution, giving due regard to the applicable factors set forth in Florida statutes. Further, enter an order to temporarily restrain the husband from incurring any further debt for which the wife may deem liable until a final determination is made in this cause. Does she say that she should be restricted from incurring any further debt that the husband could be deemed liable? No. It's one-sided. G, prior to and at the time of final hearing, the petitioner husband should be required to contribute to the respondent wife's attorney's fees and costs per Florida statute, in addition to awarding fees should she engage in unnecessary or vexatious litigation temporarily and or permanently. Wait, so she's saying that the husband should be required to contribute to the wife's attorney's fees and costs in addition to awarding fees should she engage in unnecessary, vexatious litigation temporarily and or permanently. So she's requesting that if she engage in unnecessary litigation that those fees should be awarded to her. I don't understand how that's worded. H, restore the wife's maiden name to Sarah Catherine Paulson. I, grant such other relief as this court determines appropriate, which is the catch-all. Count 2, partition. This is an action for partition. The wife pleads. This is an action for partition only in the alternative. Partition is hereby requested pursuant to Chapter 64 Florida statutes of the following described real and personal property owned by the husband and wife, subject to the outstanding mortgage on the property. The property sought to be partitioned is located in Winter Park, Florida, more specifically described. Title to the property is vested in the names of Brian Boone and Sarah Boone as husband and wife. The court has jurisdiction over the property and venue is proper in Orange County, Florida. The balance owing on the mortgage note is approximately $250,271.05 as of the date of this petition. The lien holder is City Mortgage. There are no other persons who are lien holders or who otherwise own an interest in the property. So I think Brian's claim said $252,000. She's saying it's a little bit less. It's not that serious. I'm sure the bank could provide a statement. The property consists of a single-family home located on a platted plot. Therefore, the property is indivisible and not subject to physical division without prejudice to the parties. Wherefore, the wife, Sarah Boone, requests that this court enter a judgment of partition pursuant to Florida statutes, appoint a special master of clerk of circuit court to make a sale of the property either by private sale or at a public auction to the highest bidder pursuant to this section of Florida statutes. Isn't that what Brian said? Order that each party's respective share of the cost of this action, including attorney's fees, be paid out of the sale proceeds, with the remaining monies divided among the parties in proportion to their respective interests. Grant such other relief as this court deems just and proper. I'm going to have to go back and look at that side by side because I thought she denied what he said. Give me just a minute. Okay, I put these back up here along with the section that I just read from Sarah's. So Brian's number 4 that you see up here, she denies number 4 in the red box. Wife denies the partition claim should be granted and denies that any attorney fees should be awarded. Does she mean only to Brian, but she can be awarded? Because Brian's number 4 says, the husband requests that this court take jurisdiction over this action for partition and enter a judgment of partition, appoint a special master or clerk of court to make a sale of the property either by private sale or at a public auction to the highest bidder. Sarah says, enter a judgment of partition pursuant to the section, appoint to a special master of clerk of court to make a sale of the property either by private sale or at public auction to the highest bidder pursuant to Florida statute. So that's identical to what he had. But up here, it says she denies the partition claim. But here it says she requests the court do that. And then C, Brian says, order that each party's respective share of the cost of this action, including attorney's fees, each party's share, including attorney's fees, that means both parties' attorney's fees, be paid out of the proceeds of the sale, with the remaining monies divided among the parties in proportion to their interest. And then her letter C says, order that each party's respective share of the cost of this action, including attorney's fees, be paid out of the sale proceeds, with the remaining monies divided among the parties in proportion to their respective interests. The only thing she added is the word respective. But up here, she denies it, says that she doesn't agree with it, but then she requests the court do the exact same thing. Does that make any sense? Okay, this is my little timeline for the Boone versus Boone family court case. I made this just for myself, but I also shared it on the post if you want to look at it. But so far, we have looked at the case initiated and the petition for divorce filed that Brian filed via his counsel. I didn't show you the notice of appearance, but Brian has a lawyer that put in her notice of appearance, and then we looked at his financial affidavit. Then we looked at the notice of appearance of counsel for Sarah. We looked at Sarah's answer, counterclaim, counter petition. We saw the letter requesting her filing fee, which was posted on the 18th, and it is still outstanding. The certificate of compliance is just a checklist that Brian's attorney filed showing that he provided all the required financial documents to support his financial affidavit. So I didn't pull that up because it was just a list of things he submitted. We are about to look at the answer to the counterclaim now that Brian filed via counsel. And we've already looked at the motion to withdraw at the beginning of this case. So these are all of their preliminary documents that were filed. We're going to look at Brian's answer to Sarah's counterclaim. And then just so you know, there's only a few other things here. On May 9th, there's a property settlement that Brian filed with his attorney, a parenting plan. Sarah wrote an answer and a waiver of her appearance, which is hilarious because if I haven't posted anything about her recent, she just posted this yesterday that she is insisting to appear in person when the judge wrote an order for her to appear by phone at their hearing. But when she was free as a bird walking around Boozy the bear, whatever, and drinking and whatever, she just waived her appearance at this final hearing, which is crazy to me, and filed her financial affidavit that day of the final hearing. And then there was a support guidelines worksheet that the state fills out for any case involving child support or financial support. And then on the 15th, we have the court's final judgment. that we will look at. So these are the last, we're going to look at Brian's counter petition, and then these other things will kind of be quick. Sarah's financial affidavit is quite interesting, so make sure you stay tuned for that. So here's kind of our timeline where we're at. We're about to look at this, and then we will do these really quick, boom, 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 and then look at the court's final judgment from June 15th, 2018. That is their current parenting plan and final divorce judgment. Okay, so here is Brian's answer to the wife's counter petition and other related relief. So the husband, Brian C. Boone, by and through his undersigned attorney, answers the counter petition for dissolution of marriage and other related relief filed by the wife, and states as follows. 1. The husband admits the allegations contained in paragraphs 1 through 3 of the wife's counter petition. 2. The husband denies paragraph 4 of the wife's counter petition as to the date of final separation. 3. The husband admits the allegations contained in paragraphs 5 through 8. 4. The husband admits that the parties should be granted shared parental responsibility as alleged in paragraph 9 of the wife's counter petition, but denies as to the remainder of allegations contained therein. 5. The husband admits the allegations contained in paragraph 10 of the wife's counter petition. 6. The husband admits that he should maintain health insurance for the child and that the parties be responsible for uncovered medical expenses based upon their respective incomes, as alleged in paragraph 11 of the wife's counter petition, but denies as to providing 36 months of COBRA insurance for the wife. And I agree. That is outrageous. 7. The husband denies the allegations contained in paragraph 12 of the 8. The husband admits the allegations contained in paragraphs 13 of the wife's counter petition. 9. The husband denies that the wife should remain in the home during these proceedings, as the property has not been properly maintained by the wife and the property needs to be readied for sale. The remaining allegations contained in paragraph 14 of the wife's counter petition are admitted. 10. The husband admits that the wife has employed the Marks law firm as alleged in paragraph 15 of the wife's counter petition. The husband is without knowledge as to the remainder of the allegations and therefore denies the same. 11. The husband admits the allegations compared in paragraph 16 of the wife's counter petition. Count 2, partition. The husband admits the allegations contained in paragraphs 1 through 7 in count 2 of the wife's counter petition, unlike Sarah, who disagreed with them even though they were the same. So that's what that said. The marital settlement agreement that was filed on May 9th, 2018. Marital settlement agreement. This agreement made this 3rd day of May 2018 between Brian C. Boone of Orange County, Florida, hereafter called husband, and Sarah K. Boone of Orange County, Florida, hereafter called wife. Witnesseth, whereas the parties were married to each other on the 21st day of August 2004 in Orlando, Orange County, Florida, and have lived together as husband and wife, and whereas unhappy differences have arisen between the parties and they are living separate and apart, and whereas the parties desire to settle their respective property rights. Now, therefore, in consideration of the premises, it is mutually covenanted and agreed as follows. 1. Separation. After the date of this agreement, the husband and wife shall continue to live separate and apart from each other as if they were unmarried. Each party shall be free from the control and authority of the other, and each may reside at such a place as he or she may select. And they've initialed the bottom of each page here. So that's interesting that they are to be free from the control and authority of the other. However, Sarah keeps trying to control and establish authority over Brian. 2. Behavior. Neither party shall annoy, threaten, or otherwise interfere with the other party. Neither party shall attempt to compel the other to cohabit with him or her by any means. Now, Sarah obviously can't compel Brian to cohabit with her in prison, but if we look at the phone call logs that I have covered, there's definitely some of this going on. Okay. 3. Subsequent divorce. This agreement shall be filed in the pending action for dissolution of marriage subject to the following. A. Neither party shall make any claim for alimony except as provided in this agreement. B, neither party shall make any claim for attorney's fees or cost except in accordance with the provisions of this agreement. C, this agreement shall be offered into evidence by either party in the dissolution of marriage proceeding and, if acceptable to the court, shall be incorporated by reference in the final judgment. This agreement shall survive the final judgment and be binding upon the parties for all times. So this is in Sarah's favor, that this agreement is binding for all times, because she wants it to be continued to be enacted in some ways, but not others. Like, she doesn't want to pay half of all the medical costs of the child, but she just wants the financial part to be enforced and the time sharing to be enforced, even though it's a huge inconvenience to the single parent solely raising the child. D, a modification or waiver of any of the provisions of this agreement shall be effective only if made in writing, signed by both parties, and properly witnessed and notarized. 4, mutual releases and indemnification. Except as otherwise provided in this agreement, each party releases the other from all claims or demands he or she may have up to the date of this agreement. Like claims and demands for a storage unit or a Kia Sorento. Except as otherwise provided, each party waives and relinquishes all rights that he or she may have or hereafter acquire. 1, to inherit under any will or codicil of the other party now in effect. 2, to share in the other party's estate under the laws of descent, including elective share. 3, to act as personal representative of the other party's estate. Oh, so Brian's not allowed to act as your personal representative of your estate, your Kia Sorento, your family heirlooms stuffed in your storage unit that he was probably having to pay for. Moving on. Number 4, to share in any proceeds from an insurance policy and employee benefit. That continues down here. An employee benefit plan, a retirement plan, a profit sharing or pension plan in which the spouse was designated as a beneficiary prior to the execution of this agreement. So it's saying that unless it's in here, they're relinquishing all rights that he or she may have hereafter to acquire any of these benefits, which she is asking. We'll see later on in the current case, which is coming up on Monday. C, each party agrees to indemnify and hold the other party harmless from any claim, demand, or judgment for damages that may be assessed against the other for failure to pay any obligation which that party has assumed. So you can't hold Brian responsible for failure to pay an obligation that you have assumed. Your obligation is your division of property in this agreement. So it's your obligation to store it, pay for that storage, pay to park your car, whatever. It's your responsibility. But what did you do when you got arrested? You called Brian and said, "Can you please handle this for me?" and expected him to just indefinitely continue to accrue costs on your behalf. No. D, within a reasonable time after written demand, each party shall sign all documents necessary to carry out the intent of this agreement. A party who fails on demand to comply with this provision shall pay to the other party all attorney's fees, costs, and other expenses reasonably incurred as a result of that failure or the enforcement of the obligation. E, if any provision of this agreement is held to be invalid or unenforceable, all other provisions shall nonetheless continue in full force and effect. So they're saying if any one part of this is invalid, all the rest of it is still in full force and effect. So failing to comply with the provision means they should have to pay the other party's attorney costs. That's interesting because Sarah has failed to comply with some of this. So if she really wants everything in here to be enforced, then she needs to pay Brian's attorney costs. as well. Financial disclosure. Each party has made voluntary financial disclosure available to the other, and each party waives formal compliance with the discovery requirements of the Florida Family Law's Rules of Procedure. The parties have filed financial affidavits. 6, shared parenting responsibility of the child. There has been one child born of the marriage, born in 2010. No additional child is expected. The parties shall comply with the provisions of the parenting plan executed simultaneous with this agreement. Support for child. As for a contribution towards the support of the minor child, the husband shall pay to the wife the sum of $100 per month. The first payment shall be made directly to the wife on May 1st, 2018, beginning on the first day of the month following the entry of the final judgment. The payment shall be made through the state of Florida disbursement unit until terminated by court order. Agreement between the parties or upon the child reaching the age of 18 years, whichever shall occur first. In the event the minor child is a full-time high school student, upon reaching his 18th birthday, the obligation for support shall continue through the end of that school year, but not later than his 19th birthday. Upon the minor child reaching the age of 18 and graduating from high school, the child support obligation shall cease without further order of the court. Now, this is based off of the child support worksheet that they filled out that I will show you. And it is based off of Sarah having a slightly less monthly income than Brian. That's why he's giving the $100. Their situations have significantly changed to where Brian is not sharing the child 50% of the time with Sarah, where she would have 50% of the responsibilities and expenses of the child. So the child support worksheet will have to be amended based on this change in circumstances. That's how this works. I'm not a lawyer. I'm not trying to give professional advice, but I am saying that there has been a significant change since they filled out this child support worksheet in 2018. And so she's not entitled to this $100 anymore because Brian is bearing 100% of the cost of raising the child now. 100%. Okay. Upon termination of the husband's alimony payments, as described below, the parties shall exchange statements of income along with supporting documentation and shall recalculate child support pursuant to the guidelines. So they're saying when his alimony runs out, they have to fill out the support worksheet again and reallocate funds. 8, medical and hospitalization insurance and expenses for minor child. The husband shall continue to include the minor child on his medical and hospitalization insurance policy and shall be responsible for the premiums on the same. Each party shall be responsible for 50% of the minor child's ordinary and necessary medical, medication, dental, orthodontic, eye care, counseling, or similar expenses not otherwise covered or reimbursed by insurance, including deductibles and copayments. So this is one of those things that Sarah should be paying 50%, including the copay. Where was I? The party incurring the expense shall notify the other party and provide proof of payment within 30 days of payment. The other party shall reimburse his or her half within 30 days thereafter. Wife's health insurance. Following the entry of the final judgment, the wife shall be responsible for obtaining her own health insurance and for all of her unreimbursed and uncovered health-related expenses without contribution from the husband. 10, head of household dependency exemption. This is just about filing taxes. So the husband shall be entitled to file head of household based on the parenting plan. Should tax laws change, again, allow for a dependency exemption, then the husband will be entitled to claim the minor child as his dependent for federal income tax purposes. The wife agrees to sign the declaration required by the IRS to effectuate the provision and provide it to the husband. 11, this is Sarah's big contention. Right here, durational alimony. Beginning May 1st, 2018, and continuing on the first day of each month thereafter, the husband shall pay the wife the sum of $1,000 per month as and for durational alimony. Said payment shall be made by direct deposit from the husband's bank account to an account that the wife shall designate. Upon the death of either party, the wife's remarriage, or after 84 payments have been made, whichever shall occur first, the obligation to make further payments shall cease except for any arrears. Now, this is what the judge has to rule on coming up Monday. The alimony amount is modifiable upon a showing of a substantial change in circumstances, but the duration cannot be extended for any reason. Okay. So that means he can't continue to have to pay it or be obligated to pay it past the deadline, which was April 2025. And Brian did file for a modification in 2022, which we will see, showing a substantial change in circumstances, whereas he is now responsible for 100% of the financial responsibility and care of their child. The alimony payment shall be included as income to the wife and deducted by the husband for federal income tax purposes for as long as alimony continues to be paid. In the event of a modification of the amount of the alimony payment shall be based on the tax law in effect prior to the Tax Cuts and Jobs Act of 2017. The Tax Cuts and Jobs Act of 2017 does not apply to modifications, and the payment shall continue to be taxable to the wife and deductible by the husband for federal income tax purposes. So she has to claim it as income, which will be interesting for her now being incarcerated. If she were to be awarded the alimony, she would have to file a tax return and claim it as income and owe taxes on it. So there's that. 12, lump sum payment to effect equitable distribution. As in for equitable distribution, the husband shall pay to the wife the sum of $22,000, which represents approximately 1/2 of the wife's outstanding credit card balances. Good Lord. You have $44,000 in credit card debt? That is a lot. That is a lot. So he's going to make the lump sum payment to her of $22,000, and that's going to cover half of her credit card balances. That's significant to me that those are her credit card balances because they're splitting their debts. So that doesn't include any that he had. That's just hers. The husband shall make this payment within 30 days following the entry of the final judgment. The wife shall be solely responsible for the balances due on her credit cards without further contribution from the husband. Personal property. The parties have previously divided their furnishings and personal property. The wife shall retrieve the remainder of her personal property from the marital home within 14 days from the date of this agreement. So after 14 days of the date of this agreement, which was May 3rd, 2018, she's supposed to have dealt with all her personal property. And at that point, Brian is not responsible for it. So it doesn't matter what happened to the storage unit. It wasn't his responsibility. Vehicles. The wife shall retain the infamous 2011 Kia Sorento titled in her name as her separate property, free from any claim of the husband, and I would say from any responsibility. The wife shall be responsible for securing her own car insurance not later than April 1st, 2018, which would be back because this was signed on May 3rd. The husband shall retain his 2011 Toyota Prius titled in his name as his separate property, free from any claim of the wife, and the husband shall be responsible for his own car insurance. And then we get to bank accounts. The parties shall close their joint bank account and equally divide the balances, if any. Each party shall retain all bank and brokerage accounts in his or her separate name, free from any claim of the other party. So all her requests to see his bank accounts, his credit card statements, this and that, he's free from any claim of the other party according to this. Again, I'm not a lawyer. I'm not an expert. We'll have to see what happens on Monday. 16, retirement. Each party shall retain any retirement funds in his or her name, free from any right, claim, or interest of the other party, which she keeps asking about his 401k. You don't have a claim to it. Further, each party shall be solely responsible for any and all loans taken against his or her retirement funds and shall indemnify and hold the other party harmless from all liability thereof. Indebtedness. The parties acknowledge that no joint debts are known to exist other than the mortgage on the marital home. If a past joint obligation is discovered, the party who incurred it shall be responsible for its payment and hold the other harmless from any liability on it. Neither party shall incur any obligations for which the other party may be liable. Neither party shall incur any obligations for which the other party may be liable, like a storage unit. If so, the party incurring the obligation agrees to hold the other harmless and indemnify him from or her from any loss, damage, costs, or attorney's fees connected with that obligation, like a storage unit. Each party shall be responsible for any and all debts currently in his or her name and shall indemnify and hold the other party harmless from all liability. And here's their property. The parties own the former marital residence located in Orange County, described as follows. Simultaneous with this agreement, the wife shall execute a quitclaim deed transferring her interest in the property to the husband, subject to the following. The husband shall be solely responsible for the outstanding mortgage and shall indemnify and hold the wife harmless from any liability on it. The husband will satisfy the balance on the mortgage within 60 days from the entry of the final judgment. The whole balance in 60 days? I mean, unless they sell it in 2 months, I don't know. The husband shall pay to the wife the sum of $10,000, which represents the wife's equity in the marital home. So he was required to already pay her equity from the home. She doesn't have any more claim to it besides what's in here. Said sum shall be paid within 30 days following the entry of the final judgment. The husband shall pay all taxes and insurance for the current and succeeding years. Wife transfers to husband her interest in the escrow account, if any, with the mortgage company as of this date. She's not responsible for any shortage, nor does she have a claim to any excess on that account. Wife assigns to husband her interest in the homeowner's insurance policy covering the property. Husband shall pay any necessary fees incurred resulting from the transfer, including recording fees, documentary stamps, and mortgage company transfer costs, if any. Husband's attorneys. Wife acknowledges that she had previously been represented by the Marks law firm, who withdrew from representation. The wife acknowledges that she has been advised to have this agreement reviewed by independent counsel. The wife affirmatively states that she has not received any legal advice from Sasser and Weber, PA, which firm represents the husband only. The parties acknowledge that the firm of Sasser and Weber, PA, which prepared this agreement, represents the husband only and has not rendered any legal advice to the wife. The parties agree that this agreement is the result of negotiation, and any ambiguity contained herein, if any, shall not be construed against either party. So you can't use ambiguity to get your way. Representations. Each of the parties represents and states each to the other that he or she has made a full and complete disclosure of his or her current financial condition and personal state of health. Each party has made voluntary financial disclosure to the other, upon which each party has the right to rely. Except as previously provided, each party waives any further discovery requirements of the Florida Family Law Rule. They waive any further discovery requirements. Each of the parties hereby represents and states that he or she is signing this agreement freely and voluntarily, intending to be bound by it. Each of the parties understands, agrees, and stipulates that he or she has incorporated into this agreement his or her full, complete, and entire understanding and agreement. That this agreement constitutes the entire contract of the parties and supersedes any and all prior understandings between them on the subjects covered. Further, the parties agree that no statement, conversation, agreements, understandings, representations, or other matter of whatsoever character which has heretofore occurred or transpired between them, except as herein expressly set forth, shall have any force or effect, like tablet messages. So if someone said they were going to, for instance, buy someone a hot meal, they're not, like, there's no force or effect to that. Construction. This agreement is executed and delivered and shall be performed in the state of Florida and shall be interpreted, construed, and enforced in accordance with the laws of the state of Florida. If any provision of this agreement is held to be invalid or unenforceable, all other provisions shall remain in full force and effect. And this is the signature notary of Brian and of Sarah. So that is their final agreement that they came to agree on through, I'm assuming, mediation. They said negotiation in here, but through mediation. Okay, this is Sarah's financial affidavit that she filed with the court on 5/9/2018, the day she waived her appearance at the final hearing to have her voice heard and how important that was. Notice the source of income she listed was unemployment. It says monthly, $386 monthly, but then she wrote on the side, multiplied by 2 is $772. So I don't know if she means she gets $386 every 2 weeks, and she didn't realize it said monthly or what. And then where it says check here if unemployed and explain on a separate sheet of paper, she wrote on the back. So let's take a look at what she wrote, because that's her only source of income she claims. And she says, I am applying online and in person on a daily basis to find a new job. I also have had some interviews in the meantime and continue to from the applications and resumes submitted. It's so jargony. I have had some interviews in the meantime and continue to. It's like, that's not, I would have said, I have had and continue to have interviews from the applications and resumes submitted. That would make more sense to me. But of course, this is Sarah. We know how she writes. And now we have documented proof in her own handwriting that she submitted to the court that she has been riding the coattails of the Florida taxpayers since at least 2017. So there's that. This is the state child support worksheet that the court uses to determine child support, and it was also filed on 5/9/2018. Notice on the second page at the bottom, the highlighted portion says that Sarah Boone's income is based on a 40-hour minimum wage employment. They automatically assign that to an unemployed party when they're calculating child support. So that's what they did for her. And then they show a gross income for Brian of about $4,000 and Sarah $1,430 she would get from working 40 hours at minimum wage in 2018. They have deductions for taxes and things like that. Spousal support from Brian minus $1,000 to Sarah plus $1,000 leaves them each around $2,000. So Brian's a little bit higher there. They're showing the percentage of financial responsibility based off of those incomes. Brian's about 55, Sarah's about 45. They have a share of basic monthly obligation, and it shows you how they got that calculation. And then they have the basic monthly obligation times 150%. So the increased obligation, it shows the amount for Brian would be $785. Sarah, it would be $642 for a total of $1,427. Overnights are split pretty evenly, 183 nights a year and 182 nights a year for 365 total. The parent support multiplied by the other parent's percentage of overnights. And then the total monthly childcare cost, Brian is paying $30, Sarah's paying nothing. And then the insurance costs, Brian is paying $74 and Sarah's paying nothing. So on page 2, they give him credit for that. So additional support payments, it shows Brian at 57, Sarah at 47 for a total of 104. Brian gets credit for the childcare and the health insurance, leaving his total child support owed at $391 and Sarah's total owed at $369. And then after adjustments, the actual difference would be $22. So that's how they calculated that. And I guess they just rounded it to $100 as a minimum in the final order. The parenting plan that they agreed on also filed on 5/9/2018. It lists the parents, the mother and father. Snoopy's barking outside if you hear him. They provided address, telephone numbers, email addresses to each other in the event that contact information changes. The parents will update each other within 24 hours of the change. They have one child. This is the jurisdiction if you want to read it. Parental responsibility and decision making. Shared parental responsibility. It is in the best interest of the child that the parents confer and jointly make all major decisions affecting the child's welfare. Major decisions include, but are not limited to, decisions about the child's education, healthcare, religion, and extracurricular activities. Day-to-day decisions. Each parent shall make decisions regarding the day-to-day care and control of the child while the child is with that parent. Either parent may make emergency decisions affecting the health or safety of the child when the child is residing with that parent. A parent who makes an emergency decision shall share the decision with the other parent as soon as reasonably possible. So, who is the child residing with? Brian. So that's who's making these decisions. Extracurricular activities. The parents must discuss and mutually agree on activities. The parent with the minor child shall transport the child to and from the activity, providing all necessary uniforms and equipment within the parent's possession. Each parent shall provide food, clothing, shelter, school supplies, lunch money, entertainment expenses, etc. for the minor child when the child is in his or her care. So right now, the child is solely in his father's care. So he's providing all of these things, and Sarah is not. Prohibition on alcoholic beverages. The wife shall not consume alcoholic beverages when the child is in her care. In the event that this provision is violated, the time sharing shall be supervised only at the father's discretion unless and until the mother completes a treatment program. Interesting. So this was in here and she initialed it and agreed to it. So that could be one of the reasons she did not get her son on days she was supposed to get him if she had been drinking, because then she would have to go into a program. So that's interesting, isn't it? Recognition of children's rights. The child has the right to have two parents and to love each of them without fear of anger or hurt from the other. Now, do you think that the child is without fear of angering one or the other? Definitely not with Sarah. The child has the right to develop an independent and meaningful relationship with each parent and to respect the personal differences of each parent and each home. Home, you would not consider the prison to be a home. Also, this does give Sarah some leeway when she's saying that she should be able to have a relationship with her child. So that is listed in here. She should be able to establish a relationship with him, and it should be on the child's terms. The child has the right to be free from being present during the parent's personal battles or being used as a spy, messenger, or bargaining chip. So asking him to read letters. We're going to see in one of her letters coming up that she has him open some mail from the court, knowing that that's putting him right in the middle. And she wrote that letter and put it into this family court docket. So it's documented in her own admission. The child has the right to enjoy the mother's family and the father's family, to see each of the families as being different from each other and to not have these differences referred to as better or worse. She does write in her letters kind of saying she doesn't have any family. I don't know if that's really relevant to what they're talking about on Monday. The child has the right not to be questioned about the other parent's life. And we know this is something she constantly does. She's admitted it herself. The child has the right not to hear parents speak ill of each other, nor to have to hear about the difficulties with the other parent. That is very hard to do, especially if you're being called constantly and having to talk to the parent. It's hard to get out of earshot of the child sometimes, depending on when they're calling. So that can be hard to accomplish when you have the child with you 100% of the time. If she is calling wanting to talk to him about things and then talking to the son about them, as she has admitted to doing. The child has the right to see his or her parents being courteous to and respectful of each other. Now, these letters Sarah has written to the court that are public information are not courteous. As to their phone calls and interactions, we can't speak. The child has the right to develop and maintain age-appropriate activities and friends without fear of losing time with a parent. The child has a right to his or her roots, which include grandparents, uncles, aunts, and cousins. The child has a right to be a child, to be free from the parent's guilt and not to assume adult or parent roles. So we'll see some of that in her letters, and we can refer back to this. Information sharing. Both parents shall have access to medical and school records pertaining to the child and permitted to independently consult with any and all professionals involved with the child. The parents shall coordinate with each other in sharing information related to the health, education, and welfare of the child, and they shall sign any necessary documentation ensuring that both parents have access to said records. Notwithstanding the above, each parent shall be responsible for obtaining records and reports directly from the school and healthcare providers. Both parents have equal rights to inspect and receive governmental agency and law enforcement records concerning the child. So that means that Brian is not obligated to provide you with a healthcare record of your child. You are responsible to get it yourself. You don't have to provide the school calendar to the other parent. They can go on the school website and print it out. Both parents shall have equal and independent authority to confer with the child's school, daycare, healthcare professionals, and other programs regarding the child's well-being. Both parents shall be listed as emergency contacts for the child. If the child is injured, the parent with the child shall contact the other parent as soon as is practicable. Each parent has a continuing responsibility to provide a residential mailing or contact address and contact telephone to the other parent. Each parent shall notify the other parent in writing within 24 hours of any changes. Each parent shall notify the court in writing within 7 days of any changes. School calendar. This is what I just mentioned. On or before July 1st of each year, both parents should obtain a copy of the school calendar for the next school year. The parent shall discuss the calendars and the time sharing schedule so that any differences or questions can be resolved. The parents shall follow the school calendar of Orange County, Florida. When defining academic break periods, the period shall begin at the end of the last scheduled day of classes before the holiday or break and shall end on the first day of regularly scheduled classes after the holiday break. A parent making a request for a schedule change will make the request as soon as possible, but no event, except in case of emergency, less than 48 hours before the change is to occur. A parenting request of schedule shall be responsible for any childcare or transportation costs caused by the change. And this is their time sharing. The parent shall exercise time sharing with the minor child in accordance with the calendar attached as Exhibit A. Specifically, the minor child should be with the mother every Monday and Tuesday overnight, with the father every Wednesday and Thursday, and alternate weekends with each parent from Friday after school until the child's return to school on Monday morning. If the child is sick and cannot attend school, then the parent who had the child the night before shall be responsible for the child's care during the missed school day. Holiday schedule. They have a holiday time schedule shown below. It will take priority over regular weekday, weekend, and summer schedules. If it is not specified as even or odd every year with one parent, then the child will remain with the parent in accordance with the regular schedule. So you have Mother's Day every year, Father's Day every year to the mother or father, and then even years or odd years dividing up these holidays. For Thanksgiving, the child shall be with the father for the entire Thanksgiving school break in even years and the mother in odd years. The child's birthday, both parents shall have access to the minor child on his birthday every year, and the minor child shall be with each parent on that parent's birthday every year. Now, obviously, this has to be amended because the child cannot be with the mother on every single one of these days. If a parent has the child on a weekend immediately before or after an unspecified holiday or non-school day, that parent shall also have the child for the holiday or non-school day. For example, if there's a teacher work day or unspecified holiday that falls on a Monday, then the weekend parent shall return the child to school on Tuesday morning. And then they talk about Christmas break. The parent shall equally divide the child's winter school vacation in even years. The child will be with the mother for the first half of the school vacation, beginning upon school dismissal on the last day of school until the midpoint of the break. The first half includes Christmas Eve and Christmas Day. The father shall have the minor child for the second half of the winter school vacation until his return to school following the vacation in even years. The second half always includes New Year's Eve and New Year's Day. In odd years, the child shall be with the father for the first half and with the mother for the second half of the school vacation. They talk about spring and summer break. They shall equally divide spring break. The parent who is scheduled to have the first weekend of spring break in the alternating rotation shall have the child from school dismissal until 6 p.m. on Wednesday, and the other parent shall have the child from 6 p.m. on Wednesday until his return to school on Monday. Summer, the parent shall follow the regular schedule during the summer. However, each parent has the right to 2 uninterrupted weeks for vacation, which may be taken consecutively at the option of each parent. The summer vacation shall not interfere with the holiday time sharing schedule unless the parents agree otherwise in writing. The parent shall schedule their summer vacations by May 1st of each year. In even number years, the mother gets to select her summer vacation weeks first, and in odd number years, the father gets to select his summer weeks first in the event of a conflict. Transportation and exchange. The parent beginning his or her time sharing shall provide transportation for the child. Both parents shall have the child ready on time. If a parent is more than 30 minutes late without contacting the other parent to make arrangements, the parent with the child may proceed with other plans and activities. Exchanges shall be at school or at any other place mutually agreed upon between the parties. Foreign and out-of-state travel. Either parent may travel with the child during his or her time sharing. The parent traveling with the child shall give the other parent at least 10 days written notice before traveling out of state unless there is an emergency, and shall provide the other parent with addresses, telephone numbers where the child and parent can be reached. 30 days notice and itinerary shall be provided for foreign travel. Now, obviously, Sarah's not doing any out-of-state or foreign travel at this point. I'm not sure if Brian would still need to notify her, but that would have to be amended. The child shall attend school in the father's school zone unless the parents jointly decide otherwise. So that's settled. Designation for other legal purposes. The child named in this parenting plan is scheduled to reside 183 days per year with the father and 182 days per year with the mother. Now, this is different now. He cannot reside 182 days a year with the mother. And this does not have effect on decision-making or rights. Communication. All communications regarding the child shall be between the parents. The parents shall not use the child as a messenger to convey information, ask questions, or set up schedule changes. The parents shall communicate with each other by text, telephone, email, or in person. Now, a lot of people comment, why doesn't Brian just change his number? Why doesn't he just block her? Legally, he's court ordered to communicate directly with her about their child. He cannot do that until their child is 18 or he's violating this court order. 2, between parent and child. Both parents shall keep contact information current. Telephone or other electronic communication between the child and the other parent shall not be monitored or interrupted by the other parent. Electronic communication includes phones, email, webcams, etc. The child may have daily telephone, text, Skype, FaceTime, and email contact with both parents during reasonable waking hours. So right now, the child does have daily phone access with both parents. So that's another reason they cannot block her. Childcare. Each parent may select appropriate babysitters. That's not really relevant for Sarah. They need to both agree on after-school care. Each parent must offer the other parent the opportunity to care for the child before using a sitter or relative for any period exceeding 6 consecutive waking hours. This does not apply to occasional overnight visits to grandparents or friends' homes. Changes or modifications of the parenting plan. This parenting plan may be modified or varied on a temporary basis when both parents agree in writing. When the parents do not agree, the parenting plan remains in effect until further order of the court. So this is why Brian has to tread lightly. This is in effect until further order of the court, which is what they're going to talk about Monday in court. And they were both supposed to submit a proposed parenting plan, which Brian did, and Sarah submitted a 33-page rant about her storage unit in her car. All right, relocation. Any relocation of the child is subject to and must be sought in compliance with Florida statutes, disputes, and conflict resolution. Parents shall attempt to cooperate and cooperatively resolve any disputes which may arise over the terms of the parenting plan. The parent shall use mediation or other dispute resolution methods and assistance, such as parenting coordinators, counselors, before filing a court action. And we will continue to go over these and see later on that a request for mediation was entered and Sarah was not very cooperative and then complained that she did not get to do that later. And this is just that everyone that signed and the notary, and they both initialed each page, meaning that Sarah agreed to this as well as Brian in 2018. Okay, and finally we have Sarah's filed amended answer and waiver and dismissal of counter petition filed on 5/9/2018. And it reads, the wife, Sarah K. Boone, hereby files this amended answer, waiver, and dismissal of counter petition as follows. 1, the wife neither admits nor denies the allegations contained in the husband's petition, but does not desire to present any defenses. So this Sarah from 2018 was like, I don't admit or deny what he's saying, but I don't want to defend myself. Like, I don't want to exercise my rights that are in the Florida and U.S. Constitution. Okay. So this is a whole different ballgame. 2, the wife admits the marriage between the parties is irretrievably broken. 3, the wife requests that this court incorporate the provisions of the marital settlement agreement and parenting plan dated the 3rd of May, 2018 into its final judgment. 4, the wife hereby dismisses her counter petition filed in this cause. So she totally withdrew that. 5, the wife waives her right to personally appear at the final hearing, provided that the final judgment is entered consistent with the marital settlement agreement and parenting plan. And she signed and dated this May 3rd, 2018. So isn't that interesting? We went over everything except for the final judgment. This video is kind of reaching its hour, a little over an hour already. So I'm going to put that in a separate post. I'll just post that one so you can just kind of see what it is. And if I have time, I will do a quick video on it. The next 2 things in the timeline are just 2 letters from the court asking Sarah to update her address. And then we get to Brian's petition for modification in 2022. So this is pretty much everything that was in there of any interest besides little, filing of driver's licenses and notice of appearance, things like that. So everything, you're kind of up to date with the original divorce, except for the final judgment, which I will post in the post tab. And then if I have time, I'll do a quick video, but I have been working a lot of overtime this week, so I am pressed for time on that, but I wanted to finish this and get it out so that you could kind of see it and compare it. I know a lot of other content creators have some more current stuff on the family docket, and I will get there. I kind of want to go in order because I just got access to it, so I just wanted to kind of go back and review this early stuff that I found interesting. Some of it might have been boring because, of course, I am reading legal documents, so sorry if it got a little boring. But I wanted all of this to be out there and reviewable for you, for your own background knowledge coming into this final hearing of the modification. So hopefully you can be patient with me while I go back through some of this old deep dive into the family docket, and we will soon get into some very interesting letters from Sarah, which I look forward to reading with you. So as always, thank you so much for watching, especially if you watched all the way to the end. This was a long video for me. I don't normally do any this long. So thank you so much for watching. I hope you enjoyed it, and I look forward to making more videos like this soon. So stay tuned.